reminder that this webinar is being recorded so that CAAL-CBPA members who are unable to attend the webinar are able to view the recording later. Please ensure that you mute yourself for the session unless you have to ask a question. That will reduce the background noise for everybody. If you're calling in by phone for the audio portion and don't have a mute button on your phone, *6 will mute your phone. And if you press *6 again, that will unmute you. So just a heads up, because the less people that are, the background noise that we have, the less chance of feedback and things of that nature. I'll be monitoring the chat. So if you prefer to ask your questions through the chat, or you share comments, I will pass them along verbally, but otherwise, please feel free to unmute yourself and ask your questions verbally. To start with, I'd like to do our territorial acknowledgement. The Council of Atlantic University Libraries represents member libraries from across the region.
Memorial University
is now exiting.
All of whom sit on the unceded and traditional territories of First Peoples. In Newfoundland and Labrador, our libraries sit on the homelands of the Inuit of Nunavut and Nunavut, and the Innu of Nitassinan, the Beothuk, and the Mi'kmaq peoples. In Prince Edward Island and Nova Scotia, we find our friends and colleagues situated on the territory of the Mi'kmaq. In New Brunswick, libraries are found on the land of the Wolastoqiyik, the Mi'kmaq, and Passamaquoddy peoples. We at CAAL-CBPA wish to express our sincerest gratitude to the First Peoples who share their ancestral homelands with us all. As a reminder, we do have a code of conduct for our webinars. We're dedicated to providing a positive event experience for all the participants, so we value your ideas, thoughts, and expression, and we expect attendees, speakers, and staff to show respect and courtesy toward one another. So with that, I'm going to introduce our speakers. We have 4 today. They will be presenting in order of alphabetical order, with the first being Aggie Slipwa. I always mispronounce your last name, Aggie. I apologize.
Oh, it's okay, Cynthia. Cynthia, it's Schliefka.
Schliefka. Okay, yeah, thank you.
Thank you.
She is the Copyright and Reference Services Assistant at the University of New Brunswick Harriet Irving Library. Then after her will speak Lachlan McLeod, who is the Copyright Services Coordinator at Dalhousie University Libraries. Next, we will have Leland Reed, who is the Collections and Systems Librarian at NASCAD University Library. And lastly, we will have Simon Lloyd, who is the Archives and Special Collections Librarian at the University of Prince Edward Island Robertson Library. Following the 4 presentations, there'll be time for Q&A, so please save your questions for the end of, at the end of the 4 presenters. Without further ado, I'll pass it on to Agnieszka. Thank you.
Thanks, Cynthia. Let me just share my slides here. All right. So my name is Aggie Schliefka again, and I'm a library assistant at UNB Libraries in Fredericton, New Brunswick, where I split my time between the Copyright Office and Reference Services. Before I get started, I'll show you this customary disclaimer, which tells you that this presentation is not legal advice. So over the course of my presentation, I'm going to do the following 5 things. I'm going to explain the relevance of mashup and fair dealing copyright exceptions to media projects that use third-party content. I'm going to clarify some terminology, especially around the mashup exception. I'm going to compare the mashup and fair dealing exceptions, identify a gap in Canadian best practices and workflows for transformative media projects, and finally, I'll propose a creator's workflow for transformative media. So when a user creates a new work based on parts of protected works, the most relevant exceptions in the Copyright Act are the mashup and fair dealing exceptions. These 2 exceptions apply specifically to content that is outside of open licenses. The exceptions are especially important when working with very current and culturally relevant content that is not likely to be licensed for transformative use. For example, remix works that critique politicians and current events. In the example on this slide, I reference Nancy Burson's Time cover based on a video that morphs between the shifting appearances of Trump and Putin. I encourage you to check out the link to this work on your own time. Reynolds' chapter in the Copyright Pentology explicitly connects transformative works with freedom of expression and shows how remix technologies facilitate cultural and political engagement. And it's this point about current and culturally relevant content that can help copyright staff and librarians explain the relevance of these copyright exceptions to students and instructors who've become so used to sourcing media from openly licensed resources. So let's clarify some of our terms before we keep going. The mashup exception refers to Section 2921 of the Copyright Act, which deals with non-commercial user-generated content. This section of the Act specifically targets works that borrow from or build on other works. Students and instructors may use other terms like remix, montage, found footage, etc. to describe user-generated content. But for the sake of consistency, I'm using the term transformative works for user-generated content. Reynolds gives a great explanation of the origin of the term transformative works. And the origin is in the American legal concept of transformative use. The more a work transforms an existing expression to create new meaning, the greater its claim to fairness within American fair use analysis. So delving into the specific sections, Section 2921 allows an individual to take an existing work, use it as raw material for a new work, and broadly disseminate it. The new work has to meet an originality requirement, spelled out in CCH versus Law Society of Upper Canada, and show evidence of skill and judgment. So the new work must be more than just a mechanical reproduction. To take advantage of this exception, the creator must meet the following 4 conditions. The use must be non-commercial, so no selling or advertising of products or services, even though content dissemination platforms can still profit from the use. The user should cite the original work when possible, so there is a weak attribution requirement. The user must work from a legal copy of the original work that does not circumvent digital locks. And the new work cannot have a negative economic effect on the original or harm the creator's reputation. The broad wording of this section is important here. No substantial adverse effect, financial or otherwise. And we'll come back to this in a moment, and we'll discuss why this is an issue. So fair dealing also facilitates the creation of transformative media. However, they must fall within the 8 categories specified in the Copyright Act, and they are subject to fair dealing analysis. Now, these 8 categories are research, private study, education, parody or satire, criticism or review, and news reporting. One of our speakers, Leyland, will go into more detail with fair dealing analysis, but I want to use my time to instead compare the 2 copyright exceptions. A more detailed comparison of these exceptions shows the complexity of the issues when trying to use the Copyright Act for remix media projects. One advantage of fair dealing is that non-commercial use may be fair. SCAAL's chapter, for instance, provides examples of American cases where satirical works that gain commercial distribution are deemed fair. The other advantage of fair dealing is that assessment of effect on the original work is primarily economic and likely more straightforward. The 2 disadvantages of fair dealing are that a user is limited to 8 specific categories of use, and the user cannot circumvent digital locks. Unlike fair dealing, the mashup exception explicitly enables broad dissemination and facilitates acts not covered by fair dealing. These include critiques, commentaries, homages, and other kinds of fan-based works. One of the disadvantages of the mashup exception is its non-commercial requirement. Trosso has pointed out this creates a kind of legal limbo for works that become commercial in the process, for instance, videos that go viral. Another potential disadvantage of the mashup exception is that the assessment of effect on the original work may challenge new works that diverge morally or politically from the original. SCAAL makes the point that the broad language of this section opens it up for future challenges to transformative works on moral or political grounds. If you look at these two exceptions, notice that they both require the users to work with content or with copies that are non-infringing. As many of you know, longstanding critiques of the current act, or sorry, a longstanding critique of the act has been that digital locks so frequently block users from taking advantage of copyright exceptions. And I guess it remains to be seen if the updated act will allow circumventing digital locks for non-infringing purposes. My comparison of the two exceptions leads me to my next point about a gap in Canadian best practices and workflows for creators of transformative media. There are many good examples of American organizations that do advocacy and research in the area of remix culture, but Canadian users need their own tools, such as best practices and workflows. Recently, the University of Alberta, under the leadership of Michael McNally, has released the Opening Up Copyright instructional modules, which I linked at the bottom of this slide. These videos are good conversation starters, but I still think there's a need to flesh out for users in greater detail how the mashup and fair dealing exceptions facilitate transformative works, especially given the lack of open licenses when it comes to current content. Now, this workflow captures the concrete steps that copyright staff and users can take when discussing media projects that are also transformative works. Such a workflow may help students and instructors move beyond openly licensed content and make greater use of fair dealing and mashup exceptions. And of course, this workflow will be included with the resources posted for this session. And finally, let me just share this slide deck again. These are just some examples of actual student media projects at UNB that library staff can use to test the workflow that I just shared with you. So thank you very much for your attention, and I look forward to your questions.
Thank you, Aggie.
Thank you.
Next up on our agenda will be Lachlan McLeod. And if you want to share your slides, Lachlan, very good.
Yeah, hi.
Go ahead.
Okay, hi, I'm Lachlan McLeod. I'm the copyright coordinator at Dalhousie University Libraries, and today I'll be talking about kind of copyright for theses in general, including fair dealing, but as well as some other kind of exceptions that may apply. So same disclaimer as Aggie, not a lawyer, can't provide legal advice, but also another disclaimer, your thesis policies may vary by institution. So in the past, when we were trying to determine our policies, I was looking at all the other universities, and there is quite a variety in terms of what people were advising. So just take all this with a grain of salt. As an outline for today, I'll be talking about who owns a thesis, when a student wants to use their own published material in a thesis, using material created by someone else in a thesis, fair dealing, and then we'll go into a few other exceptions and alternatives that may apply to thesis work. So who owns a thesis? So by default, the student author owns the copyright to their thesis. However, portions of that thesis may be owned by co-authors or co-researchers. So if they're working on in a lab or in a group where they are co-authoring papers or they are conducting research as a group, by default, all those people own it. There's a number of different permutations where people can own different amounts of things, and there may be one PI that owns it or just the student owns it, but by default, co-authors and co-investigators own the right to their work. Some material in a thesis may be used through licenses. The student may have sought permission to use that stuff, so just written or oral permission, or they may be using applicable exceptions from the Copyright Act, including fair dealing and some other exceptions. In rare cases, an employer can own a thesis. So this has come up for me with government employees, so someone who is in the Navy. A lot of PhD programs that go through the government, the agreement is that at the end, the PhD will be owned by your division. and be licensed or will fall under Crown copyright. One thing to note is that generally theses are licensed to the student's institution for public storage. So for us, that's DAL space. And then they are then harvested and archived by Library and Archives Canada for kind of public display. So in both these cases, these are public facing online, but non-commercial storage options. The Library and Archives website is a bit misleading. It used to be maybe worse, but now the language on it is much more limited in what it says than what you can actually do. So the website says you need to seek permission for all copyrighted works that you're using in a thesis, and many uses of these theses that would apply under the Copyright Act don't apply. However, I've clarified with them, I've emailed them and spoke with them, and as well, there's been numerous experts, including Mira Nair and Howard Knopf, who have written on this and have said that fair dealing and other exceptions do apply to theses work. So Library and Archives Canada has clarified and said that anything that is allowed under fair dealing, you have to conduct an assessment, but it is allowed. One thing to note, there was a sticking point for us in the past in determining if fair dealing and other exceptions would apply is there's a belief that they were selling or sublicensing the theses or the database to various vendors. They've confirmed to me that they no longer sell or sublicense the database or individual theses, so that kind of commercial aspect is no longer present. Using your own published material in a thesis can be more complicated than students first assume. So if they've published their material in a journal, they need to check their publisher agreement and definitely speak with the publisher to see what is allowed. Sometimes there's online FAQs or terms of use they consult, but the best thing to do is always consulting your own individual publishing agreement or speaking with the publisher. The article that they published may have been licensed to the publisher for use, or the copyright may have been entirely transferred under a variety of terms. This may require that they put an embargo on their thesis. It may require that they have to ask permission to use the article. It may require them to ask permission from co-authors. There's all sorts of permutations of this that can apply. But in many cases that I'm seeing now, publishers do allow students by default to automatically use their articles in their thesis. So good example is Elsevier. They have a publishing policy that says if you're using your own article in your own thesis, you don't have to ask permission, because generally they're providing permission for theses for free, and it's fairly easy to go through. So using other material in your thesis can get a bit more complicated than this. So the first step is asking, does an exception apply? So fair dealing, or do other exceptions apply to the material that would allow you to use it? Is it openly licensed material, for instance, that you could use? The next step is to ask, was the material licensed to you? So is it something that you're accessing through a licensed resource, and are there specific terms of use? The most common application of this is at an institution. Most electronic resources are licensed, and some of the terms of use are extremely restrictive and may be more restrictive than the allowances of fair dealing. Currently in Canada, there's no kind of consensus, but by default, what we're saying is that these types of terms of use and contracts can override things like fair dealing if they do so in the license or the contract. So if there's material being used from a licensed resource, the student may need to seek permission. Seeking permission for theses is fairly simple. There's various forms, contact information. Most journals and electronic resources are using something called RightsLink, which is an automated form process that goes through the Copyright Clearance Center, which is in the US. I've never seen a student be charged for thesis use, and generally it's easy. The only time it's difficult is if they're using, say, primary sources or other things that are difficult to obtain permission for, if they have to contact individual authors or, say, estates of authors. And one thing to know is that when a student does obtain permission to use material for their thesis, this permission would not apply to subsequent use. So the permission is specific to their use in the thesis. It wouldn't apply to their next publication. So if they take their thesis, they want to publish it as a book, then they are required to seek permission again for that book. Here's just a brief example here. So this is RightsLink. I'm here on the Biophysical Journal. This is a question I had from a student. So you would click on Get Rights and Content. You're brought to the first stage of this form. You say, I want to reuse this in a thesis or dissertation. They're going to be using the full article in this case. So because they are the author, saying the format, blah, blah, blah. So you fill out this form, and generally permission is just provided either automatically, or you have to create an account and then they give you a license for it to use it. And you would use this both if you are the author of the article or if you're using other material. Fair dealing. So fair dealing is the main exemption that people tend to employ with thesis work and in general in an educational context and research context. So fair dealing does apply to theses, but the student or with the aid of a copyright advisor needs to conduct a fair dealing assessment to see if their use would fall within fair dealing. I'm not going to go into the full details of a fair dealing assessment here, but there are tools online on our website and other people's websites as well. Again, as mentioned, they would need to reassess whether their use was fair dealing for any subsequent use. So if something does qualify for fair dealing for a thesis being stored in an institutional context, it may not apply to a commercial publication. As well, license agreements may take priority over fair dealing and other exceptions. So both licensed material from the university, but the student may have individually licensed material that they're accessing, things through a paywall, things like that, that they may have to consider. So alternatives. So one alternative is using public domain works. This comes up in classics, history, things like that. Often you do not need to seek permission for public domain works. There's a lot of question about whether scans of works that are in the public domain are in the public domain. It hasn't been tested in Canada, but in Great Britain and other places, they've determined that scans would not qualify as enough to for something to be considered a new work. So there isn't enough sweat of the brow for it to be considered a new work, but public domain is something to consider if you are looking into things where it would be easier to use. Creative Commons licensed material. So Creative Commons is a sliding scale that generally allows non-commercial use. In some cases, like no derivatives, it wouldn't really be useful for a thesis, but in most cases, if you're finding things that are licensed under Creative Commons, you're going to be able to use them in your thesis by default without needing permission. And then the third alternative that I tend to see quite a bit is Crown copyright works. So Crown copyright works are not in the public domain. They are allowed use for non-commercial purposes. However, the terms really vary by different provinces and different divisions of the government. As well, it's unclear sometimes what things are under Crown copyright and which things are not. So you may have to contact the government division or request permission from both either your copyright office or the government copyright office to determine if something falls under Crown copyright. So that's it for today, and move on to the next person. Thanks.
Thank you, Lachlan. Our next speaker is, just one second here. So our next speaker is Leland Reed, and she's here from NSCAD University Library. And we can see your slides perfectly, Leland. So if you want to start, please go ahead. Are you there, Leland? You might be muted. You might need to unmute.
There we go. Can you hear me now?
Yes, we can hear you now.
Okay, and you can see my slides?
Yes.
Okay, awesome. Sorry, just one sec. Okay, awesome. So I'm Leland Reed, and I'm the Collections and Systems Librarian at NSCAD University, otherwise known as the Nova Scotia College of Art and Design in Halifax, Nova Scotia. The NSCAD Library supports teaching, learning, and research in the areas of fine art, craft design, media arts, art history, art education, and interdisciplinary programs taught here at the university. All of us library staff here at NASCAD, we field many different types of copyright questions that range from course text to audiovisual materials, which I talked about in last year's webinar a little bit, and images, which is going to be the focus of my participation in this webinar today. Images are fundamental to what happens here at NASCAD. Students here need to have access to images in order to do their coursework, and they also are creating their own images as part of their practice as artists, designers, and researchers in the arts. So I thought the subject of images would be a fun one for me personally to look at for this year's webinar, and I know it's a subject that a lot of people have questions about. So here we go. And also before I start, I'll just make the disclaimer, I'm not a lawyer and this is not legal advice. So I'm going to start with a common question from students that I think we all get asked at one time or another as library workers in academic institutions. The question is, I want to use someone else's image in my assignment and presentation for my class. Is this allowed under fair dealing? At first glance, this seems like a very straightforward question, but it can actually be quite complex depending on the specifics. We need to gather more information from the user to determine if this is fair, as using images fairly for educational purposes really depends on the particulars of the use. To get into the question, I'm going to look at the sections of the Copyright Act that allow for educational exceptions. We're going to look at the tests we have to ask to determine if a dealing is fair, and we will also briefly look at fair dealing guidelines we have available to assist us in guiding this student. And finally, we are going to look at some specific variables that could make this either a fair or unfair dealing. I know there was a lot of interest from CAAL members around seeing how other library workers go through the workflow of these types of questions. The flow of things I'm going to go through is how I would generally look at these types of questions myself in my day-to-day work, and I hope it is helpful to other CAAL members. So let's dive in. So before we get into looking at the particulars of the question, I'm going to quickly go over some of the sections of the Copyright Act that provide the specifics for educational exceptions that are very applicable to this question. Section 29.4, subsection 1 provides the specifics for reproduction for instruction. It is not an infringement of copyright for an educational institution or a person acting under its authority for the purposes of education or training on its premises to reproduce a work or do any other necessary act in order to display it. And there is language here if a work is commercially available. So subsection 3 states, except in the case of manual reproduction, the exemption from copyright infringement provided by subsection 1 does not apply if the work or other subject matter is commercially available in a medium that is appropriate for the purposes referred to in those subsections. And there is a subsection 2 which goes into examinations and tests, but I'm not going to get into that today. And commercially available, defined in the Copyright Act, means in related to a work or other subject matter. It is A, available on the Canadian market within a reasonable time and for a reasonable price and may be located with reasonable effort. Or B, for which a license to reproduce, perform in public, or communicate to the public by telecommunication is available from a collective society within a reasonable time and for a reasonable price and may be located with reasonable effort. Additionally, the Copyright Modernization Act has specific language in section 30.4 around work available through the internet, which is where students are probably going to be looking primarily for images for their coursework. So it is very applicable to this question. And here we can see it is not an infringement of copyright for an educational institution or a person acting under the authority of one to do any of the following acts for educational or training purposes in respect of a work or other subject matter that is available through the internet. To A, reproduce it, B, communicate it to the public by telecommunication, if that public primarily consists of students of the educational institution or other persons acting under its authority. C, perform it in public, if that public primarily consists of students of the educational institution or other persons acting under its authority. Or D, do any other act that is necessary for the purpose of the acts referred to in paragraphs A through C. So there is conditions to this. The source and creator or author must be cited, and if there is a technological protection measure on the work or a visible notice on the site by the copyright holder prohibiting the reproduction of the work, then fair dealing isn't applicable. So assuming that the work the student wants to use is protected by copyright, we know that educational exceptions are available. So how do we determine if they are available for a particular use? The specific use must pass 2 broad tests or questions. Is the dealing for an allowable purpose, and is the dealing fair? So to look at the first question, is the dealing for an allowable purpose? We know that the student is asking if they can use an image for a presentation in a class where the student is receiving credit for a course. So this falls under education. So this checks out. Other allowable exceptions include news reporting, criticism, parody, and satire. The second test is a little more involved. We have to determine if the dealing is fair. And to do that, we must look at the following considerations or aspects of the dealing. 1, the purpose. We know that at this point, the goal of the user is to use the image for an educational purpose within the classroom. 2, we also want to look at the amount of the dealing. So what proportion of the copyright protected image is to be used? Is it a short excerpt or a substantial amount? In a minute, we're going to actually talk about this a little bit more and look at fair dealing guidelines to see what an acceptable amount under fair dealing is generally for images. 3, we want to look at the character of the dealing. So how is the copy going to be used and distributed? We should ask if the work will only be distributed within the class, or will it have a wider audience? If the work is going to be widely distributed, that could be deemed as less fair. 4, is there alternatives to the dealing? We should ask, is there an equivalent non-copyrighted alternative? Is it reasonably necessary to use a copyrighted image for the purpose intended? And 5, we also want to consider the nature of the work. Is there a large demand for the image? Is it published or unpublished? Is it intended for private use only, for a specific community, or is it intended to be publicly consumed? And 6, the effect of the dealing on the original work. Is the dealing going to compete with sales of the original work? If so, this is less fair. So in terms of how much of an image can be copied, we also want to look at fair dealing guidelines, which have evolved through case law and which we have available to us to assist in making decisions about copying for educational purposes. The question around how much of an image can be copied and still be considered a short excerpt comes up. And through our fair dealing guidelines, we can within reason assume that a short excerpt can include an entire artistic work, including a painting, print, photograph, diagram, drawing, map, chart, and plan from a copyright protected work containing other artistic works, such as a book or a journal, or 10% of a standalone work, although I don't think I've ever been asked for a partial image, but that might come up for others. We can also find in the guidelines that copying or communicating multiple short excerpts from the same copyright protected work with the intention of copying or communicating a substantial part of the work is prohibited. So in conclusion, is the dealing fair? And it's a little bit complicated. So in conclusion, it depends on the specific use and image in question. We want to take into consideration the provenance of the image and the nature of how it will be used in the classroom. If it is a single image from a book, an artistic work that is a short excerpt from a larger work, this would likely be considered fair. However, the dealing could be considered unfair depending on the particular factors involved. For instance, maybe the student wants to copy multiple images from a book. This could be unfair. Or if the student wanted to present a high resolution image of a work from an artist's website that is in high demand, that is likely going to be determined to be less fair than using a low res version, which could be considered a reasonable alternative. Or maybe there's a non-copyrighted alternative to the dealing. This should be considered. Additionally, if a student is looking to use an image from a website where there is a clear statement not permitting reproduction, or they are looking to distribute the image to a wider audience than just their class, these could both be considered unfair use, and it may be best to seek permission. So I think the most important thing we can do as library workers fielding image questions is to get all the details and make sure we go through all the specific questions relating to the purpose, amount, nature, character, alternatives, and effect of the dealing to determine if a specific usage is fair. Lastly, I want to mention that when students approach us with these questions, it can be an opportunity for wonderful teaching moments, especially to talk about public domain, usage of digital content, the importance of citation, and information literacy skills around finding and accessing images on the web, in books or periodicals, or through our licensed resources such as ArtStore, which is what we use at NASCAD. And particularly for students that are creating images and work of their own, it can be particularly meaningful to talk about the importance of disseminating information on how they wish their own work to be used through tools like Creative Commons licensing or visible rights statements. And yeah, that's my presentation. Thank you.
Thank you very much, Llewellyn. Our next speaker is Simon Lloyd from the University of Prince Edward Island. So Simon, if you want to share your slides.
Is that visible there now?
Not yet. Sometimes there's a lag, but we'll see. You might want to try it again because it doesn't seem to be coming up.
All right.
Oh, yep. Looks like it was there for a second.
Any luck there now?
We're seeing your screen, yes? There we go. We're into the slides.
All right, apologies for the delay. Thanks very much, Cynthia. Good morning and happy Fair Dealing Week. Look forward to seeing everybody at the parade. I assume there's a parade. My name is Simon Lloyd. I'm University Archivist and Special Collections Librarian at UPEI. And when it comes to copyright, I'm sort of the Zamboni driver, backup goaltender. I sort of accidentally evolved into this role over the years. Now, whereas my colleagues have focused on being sensible and helpful, I found myself increasingly drawn into a Seinfeldian Festivus-style airing of grievances vis-a-vis educational publishers while preparing this talk, and as I looked for applicable exceptions that might be helpful to our students. But hopefully I'll be able to salvage something useful or at least coherent. That disclaimer aside, and of course the other disclaimers apply as well in terms of this not being legal advice, views my own, not necessarily those of my employer, I do think it behooves us to have one eye on the big picture, even as we grapple with practicalities. Based on research, conversations with colleagues, and the lived reality I see at our library's service desk, I'm especially concerned that the major educational publishers, purveyors of that still prized information commodity, the textbook, may finally have figured out how to make it truly digital. This, in turn, has significant implications for how we might seek to exercise copyright exceptions for the benefit of faculty and students. It's well known, of course, that textbook publishers have been making themselves deeply unpopular for years now, most especially by steadily jacking up prices. Many in academia, including students, have been pushing back, including through public advocacy and social media campaigning, such as the hashtag TextBroke and hashtag TextbookBroke campaigns seen here. And it's underpinned by a real sense of frustration when the Simon Fraser University Library published a fact sheet last spring, politely reminding students that wholesale piracy of textbooks was, in fact, illegal. It attracted a sharply worded rebuttal in the student newspaper. This editorial did a decent job, I think, of highlighting why many students still feel trapped on the textbook buying treadmill, quote, throwing money at the bookstore and hoping for the best, close quote, in the writer's words. The main point I want to highlight here, though, is how the discussion about the broken textbook market has focused so heavily on pricing. Even the most well-organized and well-informed of the textbook publishers' critics, the US-based student public interest research groups, have talked mainly about money matters, as in their high-profile 2018 report Open 101, an action plan for affordable textbooks. And indeed, the crisis of affordability in the textbook market is 100% a problem and demands action and attention. The problem with any single-pronged counterattack, however, is that it leaves one vulnerable to being outflanked. This is especially the case when challenging large multinational corporations, who have the smoke and mirrors of illusory bargains down to a science. Enter, for example, inclusive access. It's been around for a while, but inclusive access started to really get attention as the coming thing in educational publishing circa 2017, as these examples highlight. Of particular note for Canadian academia was the enthusiasm shown by CAAL-CBPA, the Canadian Association of University Business Officers, who run most ancillary services, including bookstores, on most of our campuses, and who proclaimed inclusive access as, quote, the future of course materials at their 2017 national conference. Under inclusive access, universities agree to pay a per-student fee in return for first-day access to e-textbooks and associated digital course materials. The fee is passed on to students, of course, with only a limited time, and it has been alleged complex opt-out clause. Because of this bulk purchasing, or more accurately, bulk leasing, publishers claim they can offer substantial per-title discounts, thus solving the very crisis of affordability they helped create, which is nice of them. And as seen here, all of the major textbook players in the Canadian market, including McGraw-Hill, Pearson, Macmillan, push cost savings as a key benefit of inclusive access, along with the convenience of students gaining instant online access to textbooks and curricular materials once their registration in an inclusive access course is confirmed. Critics point out that the savings are often overstated and are unlikely to last in any case, since the publishers may well increase prices again as soon as they've locked up enough market share. Surely not. That said, it remains uncertain whether or not inclusive access really will take hold, per CAAL-CBPA, as the future of course materials. Uptake in Canada to date has been limited, even in the US, where institutions have been signing up in the hundreds. 2 high-profile lawsuits launched in recent months, alleging deceptive pricing and various tricksiness to hinder student opt-outs, are bringing much-needed critical attention to bear. But even if inclusive access passes into history as a bit of clever marketing, it will impact us all nonetheless, since it has forced the major educational publishers to finally, fully, completely go digital. If one is aggressively pushing digital distribution models, then one needs a supply chain and product that really is digitally oriented. The world's biggest textbook publisher, Pearson, announced its digital-first strategy in July. All of its 1,500 US market textbook titles will now be sold only as e-text. Semester-length rental for an average price of US $40 will be the primary distribution term. Print copies will also be available on a rent-only basis, and new editions of most print titles will no longer be updated. To make digital first possible, Pearson spent several years reworking practically every aspect of its operations, from author contracts to design to rights clearances. It is expected that the other major textbook publishers will follow suit. And I highlight a key quote from the Forbes piece about this. Pearson is using digital first as an occasion to take control, emphasis on take control over distribution channels. And we all know, I think, the main mechanism publishers use to take control in the online environment: digital rights management, technological protection measures, digital locks. Lisa De Valentino sounded an early warning on digital locks in the Canadian textbook market back in 2012. And just in case there was any doubt on the importance that publishers, especially educational publishers, still attach to TPMs and the protection thereof, their leading lobby group, the Canadian Publishers Council, highlighted this to the INDU Committee in the recent Copyright Act statutory review. Regardless of fair dealing or other educational exceptions, or even, it seems, basic decency, publishers are going to continue with TPMs, and the more so as they go all in on digital distribution through proprietary platforms. And if that basic decency crack seems gratuitous, I would point to the behavior highlighted in this recent University Affairs article. There is an entire section in the Copyright Act devoted to exceptions to help individuals living with perceptual disabilities make use of protected content, amplified by 2012 reforms, and further in 2016 to allow Canada to comply with the Marrakesh Treaty, to say nothing of legislation in a number of provinces mandating better supports for the print disabled. And yet, years later, our students and the colleagues trying to assist them still cannot get timely support from publishers because it would mean loosening digital locks and proprietary platforms. This is an especially harsh reminder of publishers' determination to retain control and disintermediate any agency, such as libraries, who are trying to help copyright users enjoy the modest benefit of exceptions to which they are by law entitled. In other words, what good are exceptions if publishers can simply use digital controls to make exceptions to the exceptions? And this is now a more pressing concern for academic libraries than ever, because students especially really are looking to us for answers. As highlighted in the major 2016-2017 student textbook survey at Guelph, the library was the #1 alternative for students who couldn't or wouldn't buy the textbook, but still wanted to read the content. Maybe there was just a copy or two on reserve. Maybe there were some older editions lurking in stacks. Any port in a storm. So they're coming to us. We have to do something. And a shout out is definitely in order here to an initiative spearheaded by my colleague Melissa Belvadi here at UPEI. Under the Textbook Access Pilot Project, library holdings are checked against course reading lists and copies of pertinent titles placed on reserve and highlighted in our reserve listing. Laudable as such as an initiative is, however, we all recognize that it cannot repair by itself the dysfunction of a broken marketplace. And of course, it may become completely inoperable in the not too distant future if educational publishers take their quote-unquote content into a proprietary cloud and lock it down. Indeed, part of the inspiration for today's talk came last semester when I discovered that a textbook I wanted to buy in hard copy for our archives, a UPEI professor was a co-author, was only available as a digital rental or an ebook purchase option not licensable by libraries. This is now standard practice, I gather, for Wiley and Pearson, and quite possibly the other players besides. In the end, we purchased a study pack of loose-leaf sheets and bound them in-house. So to conclude, when I look at a great event like the one that just took place at UPEI earlier this month, where my awesome colleagues Donald Moses and Kim Mears joined the UPEI Student Union and the government of PEI to announce an open educational development fund, and I hear advocates for open textbooks and other OERs say the future is open, my thought is, well, it has to be. Is affordability important? Sure. But when you look at the 5 R's of OER and the underpinning tenets of CC licensing, there's nothing in there about saving money. It's all about sharing content as openly as possible and limiting rights owner control. And hopefully we can all agree that's vital to balance copyright. No exceptions. Thank you very much for your time and attention.
Thank you, Simon. And thank you to Aggie, Lachlan Leland, and Aggie, Lachlan Leland, and Simon, all 4 of you. This is the point, folks, where you can ask our presenters questions. You have 2 options. You can either unmute and ask your question verbally, or you can type it in the chat and I'll relay it, whichever one is your preference. So with this, I'll open up the floor for questions and comments. Okay, so we have one in the chat. Sorry, here, I'm just going back to the chat here. So Saren Cross asked the question, in regard to the fair dealings, does video game images have similar provisions? Can researchers use a video game image for their research purposes, for example, in a journal article? And what are the requirements, if any? I'm not sure who would like to take that.
Oh, hi, this is Leland. So for video game image, so I would again, I think it would come down to specifically like where that image is coming from and what the any types of like restrictions that have been set out by the copyright holder, if any. I think it'd have to come down to the specific image in question. I don't know what other people think about that, but if there's any other comments on that.
Any of our other speakers want to take a stab at that?
One thing with video games, it may just depend as well, like anything else, if it's purchased or licensed. So if they have like a licensed game where they don't actually own it, so you know they're getting it through Steam or other things like that, akin to iTunes, then those cases they don't own it, and the license agreement may take precedent over it. So depending on their use, there may be some issues with it, but it just depends on. There's kind of, again, endless permutations. You have to look at the specific use case, the end use for what they're going to be using it for.
Thank you, Leland and Lachlan. We have a question from Pam Mayer. Pam, if you want to unmute.
Can you hear me?
Yes.
Yes.
Okay, great. My question kind of comes up based on the presentation about theses. I had a professor ask me a question here where they wanted to know if students and indeed faculty were able to publish entire dissertations on sites like academia.edu, I believe is the dot, and whether there was a specific time frame. Sorry, phone ringing. Whether there was a specific time frame for when one can publish openly after publishing formally. So, for example, he mentioned that he understood that maybe you could publish something 5 years after you published an article with a publisher. I informed him that it probably depends on the agreement with the publisher.
Yeah.
But I thought I'd get your feedback on that one.
Yeah, so like as you mentioned, there's several issues here. So the first is, as I mentioned, like you're getting permission to do stuff for your thesis versus you're getting permission to put stuff on academia.edu. So any permission that you receive for images or other things may not apply to academia.edu. So in terms of stuff that other people's material that you're licensing or you're receiving permission for or you're using under certain exceptions, it may not apply in that case. So you'd also have to do a fair dealing assessment again. The second component is if you were publishing your own stuff. So like if they're say doing this as part of a Tri-Council grant and they're looking to publish it open access in some capacity, there's better places to put it than academia.edu. So they might want to speak to a librarian about that. But then also the other aspect is each publishing agreement is going to be different about where it can go. Is it preprint versus postprint? And again, permission for putting it on academia.edu is going to be different than just the thesis itself. And then the third component, as I mentioned, which was seeking permission from your co-authors. So if you're putting it on academia.edu, you have to seek permission from your co-authors for anything that wasn't transferred to a publisher. So there's like many layers to basically each chapter or each component they're using that they'd want to check and clear before putting it on something academia.edu. That would, alternatively, they could just post a link on there to the institutional repository where it is hosted, right? So posting the actual thesis is a lot more difficult than just sharing a link to like the institutional repository or sharing a link to Library and Archives Canada.
That's great. Thank you.
Thank you, Lachlan. Next question is Kelly Bennett. She's asking, are students considered to be persons acting under the authority of an educational institution?
This comes up for us a bit as well. I don't want to talk too much, but it depends, right? So like students can be instructors as well, graduate students. They can be staff members at an institution, right? There's all sorts of scenarios. It just depends on their relationship in that scenario that they're doing something with copyrighted work. So like if they're working at a bar or if they're working as part of a certain organization, it just depends on that, organization's relationship to the university. For instance, most student unions are independent, right? So they wouldn't actually be under the authority of the institution. They're an independent organization. But if the person was, say, an instructor, a part-time instructor, or a TA or something like that, then I think they likely would be considered. Just a student in a class. So no, they would not be someone acting under the authority. I think in most cases, usually what you're seeing it play out is like the students have a lot of the same educational allowances and rights within the thing. It's not, they're not acting on behalf of the educational institution. So is there a specific exception or something that you're asking about? Because with each kind of thing, it changes between fair dealing and like 30.04 and each exception. But no, okay. Yeah, generally the students are kind of like treated differently than like someone who is, they're acting as an authority of the institution. So.
Thank you, Lachlan. Any other questions in the chat or that somebody wants to ask verbally? I have one question for Simon related to you had alluded to it in your presentation. How are they dealing with the accessibility for those textbooks? Because we do have human rights charter and all of those things. I'm just curious. I know it said that it was getting really hard, but how are publishers reacting to the accessibility requirements for using their textbook content?
Well, based on the reporting that's there, and I just highlighted the university affairs piece because it was quite recent and Canadian, but the sense seems to be not well. And it's frustrating to hear comments from accessibility offices that publishers are still very focused on putting things on proprietary platforms, keeping them as locked down as tightly as possible, even when there is a mandated, legally, and I would argue morally, ethically mandated need for them to be working to support people living with different perceptual disabilities better. The reason I highlighted that instance, though, is just to point out that there seems, unfortunately, to be still a very pronounced tendency on the part of publishers when setting up their online environments and their online distribution channels to have very little regard for various exceptions that might exist under the Copyright Act, including educational exceptions and fair dealing.
So do you see this issue being addressed in the current Copyright Act review, or is this something that doesn't seem to be on the radar in that discussion?
Well, specifically to things, and I mean, we could do a whole seminar just on this, but specifically in the in terms of things like TPM's, technological protection measures, and circumvention thereof, even for a non-infringing purpose. This got a bit of a hearing at the INDU copyright report. The wording that came out in their final report is somewhat vague and seems to be focused on things like right to repair and so on, in terms of essentially picking a digital lock, but for a non-infringing purpose. So what progress there'll be, if any, on the publication side remains to be seen, I guess.
Thank you, Simon.
Thank you.
Are there any other questions for our panelists, either in the chat or verbally? Is there anything further that our four presenters want to share with the attendees?
Just on the under the authority thing, I would just, for your institution or whoever you're representing, I would clarify the specific cases and stuff that you're looking at, that you're curious about, like what qualifies under the authority of the institution, because there's a lot of permutations where that can vary and be interpreted differently. So I would, yeah, it's pretty broad.
Thank you, Lachlan. Not seeing any more questions in the chat, and I haven't heard anybody unmute. So I'd like to thank our 4 presenters, Agnieszka, Lachlan, Leland, and Simon, for sharing their expertise and knowledge with us today on the 4 different
Is
areas.
now exiting.
And so just as a reminder, this recording will be uploaded to the CAAL website, as well as all the slide decks. And I'm hoping to get those up before the end of the week. So I will send out a message to the listservs to let everybody know when they are available. Thank you.